Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the President.
Honourable Senators, I have granted leave of absence to Senator the Honourable Franklin Cann, Senator Dr. Maria Dillon Remy, both of whom are ill. Honourable Senators, I have received the following correspondence from Her Excellency the President Paula Mae Weeks, ORTT. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Paula Mae Weeks, ORTT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces. To Mr. Ndale Young. Whereas Senator the Honourable Franklin Cann is incapable of performing his duties as a senator by reason of illness. Now, therefore, I, Paula Mae Weeks, President as aforesaid, acting in accordance with the advice of the Prime Minister, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Ndale Young, to be a member of the Senate temporarily, with effect from the 17th of March 2020, and continuing during the absence of Senator the Honourable Franklin Cann by reason of illness. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago, at the office of the President St. Anne's, the 16th day of March 2020. To Ms. Siobhan Eiffel. Whereas Senator Dr. Maria Dillon Remy is incapable of performing her duties as a senator by reason of illness. Now, therefore, I, Paula Mae Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Siobhan Eiffel, to be a member of the Senate temporarily, with effect from the 17th of March 2020, and continuing during the absence of Senator Dr. Maria Dillon Remy by reason of illness. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago, at the office of the President St. Anne's, the 17th day of March 2020. Honourable Senators, Senators are required to take the oath.
I, Ndale Young, having been appointed a Member of Parliament, do solemnly affirm that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities of the people of Trinidad and Tobago upon which I am about to enter.
I, Siobhan Eiffel, having been appointed a Member of Parliament, do swear by Almighty God that I will bear truth, faith, and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Bills brought from the House of Representatives, petitions, papers.
Minister in the Ministry of Finance.
Madam President, I have the honor to lay on the table the following papers as listed on the order paper in the name of the Minister of Finance. The report of the Central Bank of Trinidad and Tobago with respect to the progress of the proposals to restructure CLICO, BAT, and the CIB for the quarter ended December 31st, 2019. The annual audited financial statements of Tourism Trinidad Limited for the financial year ended September 30, 2019, and the annual audited financial statements of Caribbean New Media Group Limited for the year ended December 31st, 2017. Thank you, Madam President.
Thank you very much, Madam President. Madam President, I have the honor to lay on the table the following papers as listed on the order paper in my name. The Convention Concerning the Elimination of Violence and Harassment in the World of Work, number 190, adopted at the 108th session of the International Labour Conference of the International Labour Organization held in Geneva, Switzerland on June 21st, 2019. And the Recommendation Concerning the Elimination of Violence and Harassment in the World of Work, number 206, adopted at the 108th session of the International Labour Conference of the International Labour Organization, held in Geneva, Switzerland on June 21st, 2019. Thank you, Madam President.
Acting Leader of Government Business.
Madam President, I have the honor to lay on the table the following papers as listed on the supplemental order paper in the names of the Minister of Health and the Attorney General. The Tobacco Control Amendment Regulations 2019 and the annual report of the Police Complaints Authority for the period 2018-2019. I thank you.
Reports from committees.
Senator Dialsing.
Madam President, I have the honor to present the following report as listed on the supplemental order paper in my name. The 14th report on the Joint Select Committee on Local Authorities, Service Commissions, and Statutory Authorities, including the THA, 5th Session 2019-2020, 11th Parliament on an inquiry into the financial oversight and financial management systems at municipal corporations. Thank you.
Urgent questions.
Senator Mark.
Thank you, Madam President. To the Minister of Labour and Small Enterprise Development, can the Minister indicate how will pandemic leave be implemented in the private sector?
Minister of Labour and Small Enterprise Development.
Thank you very much, Madam President. Madam President, I've only just about 10 minutes ago ended a meeting which I partially chaired in the absence of the substantive chair of the National Tripartite Advisory Council. And those recommendations are to be placed before the Cabinet so that I am not at this point in time in a position to say what would be implemented in the private sector. But merely to say Cabinet will have to deliberate on it and the information can be brought here subsequently.
Senator Mark.
Madam President, can the Minister indicate how soon those recommendations would be sent to the Cabinet for its ultimate approval?
Minister.
Tomorrow.
Next question, Senator Mark.
Yes, thank you, Madam President. To the Honourable Minister of Works and Transport, can the Minister indicate what specific measures are in place to ensure the regular sanitation of both the water taxis and the PTSC buses?
Minister of Works and Transport.
Thank you, Madam President. Madam President, NITCO and PTSC have implemented the preventative measures in accordance with the guidelines of the Ministry of Health. In the case of the water taxi service, NITCO has enforced preventative measures based on the advisors to avoid the spread of the virus on board its vessels and at its terminal. The specific measures taken are the number seating for passengers, accommodation at each terminal and every ceiling have been reduced by 50%. This is in an effort to implement social distancing among passengers and is based on a first-come, first-served basis. Cancellation of all tours and charter service until further notice. All vessels in the water taxi service are properly sanitized before and after every sailing. All vessels are aired out before and after every sailing to allow fresh air to circulate, which will significantly reduce the spread of the virus. Air conditioning will be used only during the sailing. The frequency with which all handrails, rails, tabletop, and walls are sanitized have been tripled. Passengers are mandated to use hand sanitizers provided before entering at both terminals. Discouraging of all commuters who are displaying flu-like symptoms from traveling on the vessels. Increased vigilance by the CSR staff to identify persons who exhibit symptoms of COVID-19. Daily safety briefings on preventative for dealing with COVID-19 are done on board. The crew and staff members of the water taxi service were all briefed in a session by representative of the Port of Spain General Hospital on hygiene and preventative measures. With respect to the PTSE, a comprehensive bus sanitization plan for the Public Transport Service Corporation was developed and implemented. This includes the training of staff in proper sanitization techniques.
Minister, your time has expired.
Sorry.
Senator Mark.
Yeah. Okay. I'll go on, Madam President, may I? Because I have a few questions. To the Honorable Minister of Education, can the Minister indicate whether the Ministry is considering assigning laptops to students so that they can learn remotely while schools are closed due to the COVID-19 virus?
Minister of Education.
Thank you very much, Madam President. Madam President, the Ministry of Education is currently considering providing access to students in some subject areas, such as technical drawing, which require the use of AutoCAD. We are also currently in the process of providing resources utilizing television, online and radio for all students, including SEA, CSEC, and the CAPE. Details of this initiative will be shared with the public shortly. Thank you.
Senator Ameen.
Yes, a follow-up. I didn't hear any minister's response specifically I appreciate the other information, but specifically with regards to the use of the laptops that are in the schools for these students. If that is one of the measures being considered, that they will be assigned to the students during their time away from school.
Madam President, I'm not sure I fully understand the supplemental that the Senator is asking. Is she asking that laptops will be provided to the students, or is she asking that the laptops that are available in the schools will be provided to the students? I need to have some clarification.
The latter. Madam President, it is the latter, whether these laptops in the schools will be made available to the students.
Minister.
Madam President, it is well known that all schools are closed, and the laptops that we have in schools that are available to the students are under lock and key. And this is why I was very careful to report that we are using alternative methods to ensure that our students receive the quality education which we are determined to provide. Thank you very much.
Senator Ameen.
Follow-up. Is the minister willing to consider this measure during the time the children will be away from school because of the COVID-19 situation?
Minister.
Madam President, we do not think it's necessary to go this way. As I indicated just now, we are utilizing other alternatives, all in an effort at ensuring that our students are well served. Thank you.
Next question, Senator Mark.
Present to the Minister, the Honourable Minister of Health. In light of reports that some bars have remained open and some churches are continuing services, can the Minister indicate what measures the government will adopt to ensure compliance with its COVID-19 advisory?
Minister of Health.
Thank you very much, Madam President. Madam President, the Honourable Prime Minister would have spoken clearly yesterday, asking the country to work with us by use of his moral suasion to do the right thing. The Prime Minister articulated his wishes for the country in a very gracious manner. However, I am told by the Minister of National Security that when organizations don't comply, that he, the Minister of National Security, are looking at the following. The Minister of National Security met with the Trinidad and Tobago Police Service and the Chief of Defense Staff this morning to look at other measures, and the Attorney General, I am advised, is looking at legislative measures to address the issue. Thank you very much.
Senator Mark.
Yes. Can I immediately go to the next question? To the Honourable Minister of Health, can the Minister indicate whether the government is considering the importation of Cuban interferon alpha-2b, which is said to be successful in treating COVID-19 virus?
Minister of Health.
Thank you very much. Madam Speaker, interferon alpha-2b is already imported into Trinidad and Tobago, but for another use. WHO has not made a formal declaration that this drug is effective. However, we were informally informed as such, and the Chief Medical Officer, who is the chairman of the Drug Advisory Committee, sent it to the principal pharmacist yesterday, Monday the 16th, to convene a panel of medical specialists, including thoracic and infectious disease specialists, to look at the issue. If WHO and these specialists agree that this drug can be used, the drug is already certified for use in Trinidad and Tobago, but for other uses, then we simply have to do a new indication use, of which the Chief Medical Officer, as chairman of the Drug Advisory Committee, advises me, the Minister, and within 24 hours, once it is cleared, it can be so used. Thank you very much.
Honourable Senators, the time for urgent questions has expired.
Questions on notice, questions for oral answer.
Acting Leader of Government Business.
Madam President, the government is prepared to answer 4 of the 5 questions which are on notice. We are asking for deferral on question number 55. And Madam President, there are 2 written questions for response by 13th March 2020. Those are questions number 120 and questions number 121, and those written responses have been provided to the Parliament. Thank you.
Question number 55 is deferred for 2 weeks. Senator Mark.
Thank you, Madam President. Question number 54 to the Honourable Minister of Health.
Minister of Health.
Thank you very much, Madam President. Pursuant to Section 5(2) of the Regional Health Authorities Act, Chapter 2905, the Tobago Regional Health Authority is subject to the provisions of the Tobago House of Assembly Act, Chapter 2503, and consequently falls under the jurisdiction of the Secretary of Health, Wellness and Family Development in Tobago. I have been advised by the board of the TRHA as a courtesy that the Medical Chief of Staff of the Tobago Regional Health Authority was dismissed in November 2019. However, since the TRHA does not report to me as Minister of Health, I am unable to shed any light on the possible circumstances leading to that dismissal. Thank you very much, Madam President.
Seeing that we're dealing with a sovereign democratic republic called Trinidad and Tobago, can the minister indicate whether he would be able to access the report dealing with the factors surrounding the dismissal of the medical chief of staff of the Tobago Regional Hospital?
Minister.
Madam President, it is because we live in a democratic state, as indicated by Senator Mark, and we respect the autonomy that Tobago has. I have to kindly alert this House that as Minister of Health, I have no authority under law, as a democratic state, to inquire as to these circumstances, and I respect totally the provisions under the Tobago Regional Authority and the Tobago House of Assembly. Thank you very much, Madam President.
Senator Mark.
Courtesy, Honorable Minister, through the Honorable President, as a courtesy, would you indicate whether you can nudge the authorities in Tobago to share with you circumstances and factors that may have led to the dismissal of this particular office holder? Can you indicate to the Senate whether you'll be able to exercise courtesies in that regard?
Minister.
Madam President, there is a piece of legislation called the Freedom of Information Act. I humbly suggest to Senator Mark and the UNC that all those answers could be appropriately given to them under the Freedom of Information Act. Thank you very much, Madam President.
Next question, Senator Mark.
It's question number 56 to the Honorable Minister of Rural Development and Local Government.
Minister, Acting Leader of Government Business.
Thank you very much, Madam President. Madam President, I respond to this question on behalf of the government. Madam President, if the San Fernando Hill falls under the Forestry Division, which forms part of the Ministry of Agriculture, Land and Fisheries. Madam President, I have been advised by the Conservator of Forests that in the 18-month period, August 2018 to November 2019, there were 5 robberies at the San Fernando Hill. These robberies took place at the main office, the top of the hill, the stores department, and the play park area. Madam President, I'm pleased to advise that on each occasion, the Trinidad and Tobago Police Service, the Monrepo Police Station in particular, responded in a timely and efficient manner to the calls, and the suspects were held, charged, and they're serving sentences in respect of these robberies. In light of these robberies, Madam President, several measures were undertaken, and I'll highlight 4 of them. One is the installation of an electronic coded door at the main office, which restricts entrance and exit entrance into and exit from that area. Secondly, the area for visitors have been established and designated, and it is protected from the area occupied by the staff. The staff interact with visitors through a glass window instead of interacting in person in the main office. The third is that the collection of cash at the San Fernando Hill has stopped, and other arrangements have been made to collect cash payments in respect of activities up at the hill, and that should discourage people from coming to that area for the purpose of stealing cash. And the last thing is that Forestry Division has established a very good working relationship with the Monrepo Police Station. The officers conduct regular patrol during the day and night, and we believe that these 4 measures, among others, would improve the security and safety of the employees, the visitors, and also act as a deterrent to criminals who would like to come on the hill to commit their crimes. I thank you.
Senator Mark.
Madam President, can I ask the Honourable Minister, since the implementation of these measures, can the Minister share with us, that is the Senate, whether there has been a reduction in the number of robberies in that area since the implementation of those measures outlined by the Honourable Minister?
Minister.
Madam President, since the implementation of these measures from November 2019, there have been no robberies at the San Fernando Hill.
Madam President, is it the intention of the government to establish private security for the San Fernando Hill so that persons who use those hills can be assured of a more active security presence when their family visit those hills?
Senator Mark, that question does not arise. Okay. Next question, Senator Ubika.
Madam President, question number 7 to the Minister of Education.
Minister of Education.
Thank you very much, Madam Speaker. Madam Speaker, the ECC Center at La Plata Gardens in Valencia was approximately 94% complete when work was stopped in 2016 due to the financial difficulties facing the country at that time. This project is not on the Ministry of Education's priority list of projects at this time. The construction of this center is funded by a centralized vote in the Infrastructure Development Fund titled Construction of ECCE Centers. Although this vote received an allocation of $15 million in the fiscal year 2019-2020, the full sum of this vote has already been exhausted. As soon as additional funds are made available to the Ministry of Education for this center, arrangements will be made for work to resume. It was previously expected that additional funds would have been made available in the mid-year review in April 2020. However, the present financial crisis caused by the COVID-19 pandemic will have an effect on the Ministry's ability to access funds for non-essential items. Notwithstanding, every effort will be made to resume the completion of construction of this ECC center as soon as possible. Thank you very much.
Senator Ubika.
And based on the Minister's response, the ECC center in Valencia has remained, construction has stopped for 4 years. Can the Minister indicate how much is the cost that represents this 6% of the construction cost to complete? What dollar value is that, please?
Minister.
Madam Speaker, at this point, I'm not in a position to give that figure. I want to be careful. I don't want to give any figure that is wrong. Perhaps Senator Ubika can ask me that question on another occasion, and I'll be very happy to present the answer. Thank you very much.
Senator Ubika.
Thanks, Madam President. Can the Minister give an undertaking to present to the Senate in 2 weeks the value that represented 6% of the construction cost of this ECC center, please?
Well, I think that question was answered.
Of course.
By way of the first supplemental that you asked. You can ask another question.
Then, can the Minister indicate if this decision with the ECC centers is nationwide, because there are centers, for example, in Bonas and Cedros that are 95% complete that remain uncompleted? Can the Minister indicate if this is for the past 4 years, if it has been the policy to not complete ECC centers for our nation's preschool children?
Senator Ubika, I won't allow that question.
Can the Honourable Minister indicate, Madam President, how many children would have been catered to at this ECC center in Valencia that are now deprived of an education?
That question also does not arise. Next question, Senator Hosein.
Question number 101 to the Minister of Finance.
Minister of Finance.
Thank you very much, Madam President. Act number 1 of 2015 pertaining to the public procurement and disposal of public property states at subsection 63 that 1, the minister may, on the recommendation of the office, make regulations to give effect to the provisions of this act, including regulations with respect to A, the conduct of challenge proceedings under Part 5, and B, the addition to or removal from an ineligibility list under Section 58. And that should be Section 63, actually. 2, regulations made under this section may provide that the contravention of any regulation constitutes an offense and may prescribe penalties for any offense not exceeding a fine of $1 million and imprisonment for 5 years. 3, regulations made under this section shall be subject to affirmative resolution of Parliament. I am advised that over the period September to October 2018, the Office of the Regulator launched its stakeholder consultations in Trinidad and Tobago on the draft regulations. On the 30th of November 2018, the first submission of the draft regulations was made to the Minister of Finance. Subsequently, on various occasions in 2019, draft procurement regulations were submitted by the regulator to the minister, who sent them to legal counsel for review to determine whether the draft regulations were intra vires the Act. The Ministry of Finance also undertook its own internal review to determine whether the draft regulations were consistent with the aims and objectives of the Act. The regulator was subsequently advised of the comments of legal counsel and the Ministry's own views on the draft regulations, and the regulations were revised by the regulator and resubmitted. There were also discussions and an exchange of views on the wording of the Act itself, particularly the manner in which government-to-government contracts and public-private partnerships should be treated, as well as the disposal of public property, and whether further amendments to the Act should be made before it is fully proclaimed. The last correspondence from the regulator was received by the Minister of Finance on December the 18th, 2019, in which the regulator indicated, among other things, that his office should not be responsible for the disposal of public property, because the Office of Procurement Regulation is a regulatory and oversight body and should not be involved in matters which it is required to regulate. This point has been accepted and requires an amendment to Section 13 of the Act. The regulator also gave his views on Section 7 of the Act in that letter with respect to government-to-government and public-private partnership projects. These views will be considered in the final proposed amendments to the Act. Naturally, the final form of the regulations will flow from the final form of the Act. Following that December 18 letter, the draft regulations and proposed amendments to the Act were submitted to Cabinet and sent to the Legislative Review Committee for final review. Prior to the COVID-19 pandemic, it was anticipated that final amendments to the Act would be laid and debated in Parliament in March 2020, followed by the regulations shortly thereafter. The precautionary measures that are now being taken to contain the spread of the virus will in all likelihood affect this schedule. But barring unforeseen circumstances, we are still working towards laying the amendments to the Public Procurement Act in Parliament by the end of this month.
Senator Mark.
Madam President, through you, can the Honourable Minister share with us what were the views expressed by the regulator as it relates to government contracts? Because that he did indicate that this was only areas that has been addressed.
Minister.
The regulator sent us examples of what takes place in other jurisdictions, a number of other jurisdictions, and in most of them, government-to-government arrangements are not covered by the procurement legislation in those countries. This is what caused quite a lot of debate and discussion. At the end of it all, the regulator said that he believes that the office may be able to deal with the matter, but that is something that we in the government are looking at. We believe we need to tighten it up. We can't just leave it loosely for an interpretation of Section 7 of the Act, because it is subject to varying interpretations. It needs to be tightened up.
Yeah, okay. Senator Hussain.
May I just seek your guidance with respect to invoking Standing Order 2716 for question number 105 on the written answers list, please, to the Prime Minister?
Do you seek my guidance, or do you want to invoke the standing order?
I would like your guidance on whether or not the standing order can be invoked, because the question was deferred for 2 weeks on the 3rd of this month.
So, yes, it can be invoked, and I take it you want to invoke it?
Yes, please.
Yes, so that the standing order to question 2716 is invoked.
Requests for leave to move the adjournment of the Senate on definite matters of urgent public importance.
Senator Mark.
Madam President, in accordance with Standing Order 16, subsection 2, I hereby seek your leave to move the adjournment of the Senate for the purpose of discussing a definite matter of urgent public importance, namely the need for the government to assist small businesses in the wake of its COVID-19 countermeasures. The matter is definite as it pertains specifically to the announced responses by the government on Monday, March 17, 2020, to combat the spread of the coronavirus. The matter is urgent because the government's countermeasures has the potential to cripple small businesses, which will in turn lead to further job losses and place a number of our citizens on the breadline. The matter is of public importance because it is the government's responsibility to assist small businesses who are directly negatively impacted by this coronavirus and the countermeasures, and to ensure that the livelihood of our citizens are not severely affected by the government's course of action. Madam President, I thank you for your consideration of this critically important matter.
Honourable Senators, I have considered the motion as presented, and I'm not satisfied that it qualifies under this standing order.
Public business, government business, motions.
Attorney General.
Thank you, Madam President. Madam President, I beg to move the following motion. Whereas it is provided by Section 67(1) of the Sexual Offences Act, Chapter 1128, hereinafter referred to as the Act, that the Minister may by order amend Schedule 1, and whereas it is provided by the said Section 67(1) of the Act that every order made under this section shall be subject to affirmative resolution of Parliament, and whereas the Sexual Offences Amendment to Schedule 1 Order 2020 was made by the Minister of National Security under Section 67(1) of the Act on the 26th day of February 2020, and whereas it is expedient to approve the said order, be it resolved that the Sexual Offences Amendment to Schedule 1 Order 2020 be approved. Madam President, permit me at the immediate outset of this motion to indicate my extreme pleasure and privilege at being together with all senators present here this afternoon, and indeed honorable ministers that have attended, on the front line of Trinidad and Tobago's fight against a pandemic which has gripped our nation. Today we sit in an unusual configuration which is representative of what is called social distancing. Today we sit in a rather safe environment, but today we sit together to engage in the passage of law for the peace, order, and good governance of our society. And therefore, I am very pleased and privileged to know that this Parliament and every senator present will turn up as is required for duty to assist our country on the front line of this fight in the passage of laws for the benefit of Trinidad and Tobago. This Parliament, this Senate, is no different from the protective services, from the healthcare workers that are on the front line, from the supermarket workers that are on the front line in a new essential services industry in Trinidad and Tobago. And therefore, I am thrilled that every senator here present is willing to do the duty of Trinidad and Tobago in the privilege that we have to sit in this Parliament. And I thank all honorable senators for dealing with the matters on the order paper here today, because we have serious business for Trinidad and Tobago to perform, and I think we are required to be here to do the business of Trinidad and Tobago. Madam President, permit me to get to the substance of the motion before us. And the substance of the motion before us is something that is very important for the business of Trinidad and Tobago. What is that? Madam President, we in Trinidad and Tobago recognized years ago that our country has an issue, just like every other country, to manage the issue of crime. And in managing the issue of crime, we of course have to deal with the position of sexual offenses. Sexual offenses, Madam President, have been a feature of the common law of Trinidad and Tobago since we were a colony. They have been part of the statute law of Trinidad and Tobago since we were a crown colony. In fact, in 1861, we had the Offences Against the Persons Act. And in 1861, we dealt with the concept of rape, assault, sexual misconduct. It was in 1986 that Attorney General Russell Martineau came to the Parliament and captured in the Sexual Offences Act, Act number 27 of 1986, essentially a codification of what the law was treating with by way of sexual offenses. In 1986, we dealt with what was then a revolutionary concept of marital rape. Prior to the act in 1986 being passed, there was this untenable situation that a husband could not rape his wife, and there was debate in relation to those matters. In 1986, that was novel law. Today, it is axiomatic to our morality that that is unacceptable. In 2012, Madam Speaker, we had another event of change in Trinidad and Tobago as we birthed the Children's Act. Act number 12 of 2012, which is the Children's Act. Rather interesting passage. I recall sitting then as an opposition senator and recall supporting the government in the passage of the Children's Act. On that occasion, the independent bench did not support. That's right. And the independent bench did not support the passage of the Children's Act. It might be shocking to members sitting now on the independent bench. The independent bench did not support the passage of the Children's Act. The 3/5 majority came by the opposition and the government passing that law. And I can tell you, as a member of the opposition, I passed nearly 212 amendments to that law myself by way of recommendation. The opposition and government passing the law, the independent reserved on two very critical issues. And this tells you how Trinidad and Tobago works. One was the age of majority. Second one was the concept of same-sex relationships. Then, as Opposition Senator Faris Al-Rawi, I made a vow, if I ever had the privilege of sitting in the chair with responsibility for legislative construction, that I would abolish the age of marriage, which was the sticking point on the independent bench, one of the sticking points. And so was born the Miscellaneous Provisions Act, which we as a parliament passed under my hand as Attorney General, where we said 18 stone cold, you're a child, you cannot be married unless you are 18 years of age. And we therefore harmonized the definition of a child. You see, the Children's Act number 12 of 2012 defines a child in section 3 quite simply and quite properly as a person under the age of 18 years. But there was this absurdity in law that children could be married, and statistics have shown us a 12-year-old marrying a 55-year-old man, which in any country around the world is pedophilia. The opposition took a different point of view in relation to the abolition of child marriage. They did not support it in the Senate. We had to strip down the legislation and remove the 3/5 majority clause, but that's now history. I'm raising this because it's relevant to the motion before us. Why? Act number 12 of 2012, which is the Children's Act, abolished by way of consequential amendments contained in Schedule 3, it repealed the following offenses. It repealed the very sections that are the subject of today's motion. Number 1, sexual intercourse with a female under 14 years. Number 2, sexual intercourse with a female under 14 to 16 years of age. Number 3, sexual intercourse with a male under 16 years. Number 4, sexual intercourse with an adopted minor. Number 5, sexual intercourse with a minor employee. Number 6, householder, etc., permitting defilement of a minor under 16 years of age. Now, why did we do that? We did that because the Children's Act incorporated a very core concept. The concept is a child is anybody who's under 18 years of age. Therefore, the disaggregation of whether you're under 14 years or 14 to 16 years, or you're a male under 16 years or a female under 16 years, or you're a minor employee, it became a nonsense because we established a child at 18 years. And quite simply put, the concept of law was dealt with under the Children's Act in Section 18. Subject to Section 20, this is the Children's Act of 2012, Section 18 says, subject to Section 20, a person who sexually penetrates a child commits an offense and is liable on conviction or indictment to imprisonment for life. 19.1, subject to Section 20, a person touches a child and A, the touching is sexual, and B, the child is under 16 years of age, the person commits an offense. Subsection 2 deals with the offense creation there, and then subsection 3, person committing an offense, touching, involving, placing, and we go into the iterations of that. And then section 20 is what we refer to as the Romeo Clause, where you allow for the amorous circumstance of boyfriend and girlfriend, essentially, in innocent experimentation. So, Act number 12 of 2012, which repealed the sections traversed in this motion before us today, and this motion has a schedule attached to it. Again, let me put it on the record. We're looking at Section 6, which was repealed, sexual intercourse with female under 14. Section 7 of the 1986 Act as amended, which was repealed, sexual intercourse with a female between 14 to 16. Section 8, which was repealed, sexual intercourse with a male under 16 years. Section 10, sexual intercourse with an adopted minor, etc. Section 11, sexual intercourse with a minor employee. Section 21, householder, etc., permitting defilement. These offenses in Schedule 3 of Act number 12 of 2012 were repealed. Why? We incorporated it into the new concepts of offenses moving forward with the birth of the Children's Act. Now, why are we here today? Members will recall that we amended the Sexual Offences Act as a Senate, as a Parliament quite recently. And in doing that, Madam President, we sought to unwind a nonsense in the Sexual Offences Act. In the Sexual Offences Act, we had a provision in Part 3 of that 1986 Act as it was amended by another government in the year 2000 under Attorney General Ramesh Lawrence Maharaj, Section 34, etc. A onward was born under a new Part 3, and we had notification requirements for sex offenders. So in the year 2000, AG Ramesh Lawrence Maharaj amended the Sexual Offences Act by inserting a new Part 3. The Part 3 effectively said, a person shall be subject to notification requirements where he's convicted, sentenced, etc., etc., and a person who's subject to notification requirements shall within 14 days of his sentence, etc., notify the police in the local area. Now, how on earth are you going to be sentenced, taken into custody, and find yourself in a police station to find yourself reporting? You understand now what I mean by the nonsense of the law. What that resulted in is effectively we passed a law in the year 2000, and statistically we ended up in a gross absurdity. There was an excellent legitimate aim in the law. It passed the whole Parliament. I make no criticism of a heavyweight and giant in the legal industry, Mr. Ramesh Lawrence Maharaj. That is not the intent of what I've just said. I'm saying the law as crafted could not go into effect because there were certain absurdities in process that we had not thought out. Statistically, in Trinidad and Tobago, Madam President, the Children's Authority has said to us, and if you look to the child sexual abuse document produced, Children's Authority of Trinidad and Tobago, document entitled Child Sexual Abuse, May 18, 2015 to October 31st, 2018, we see that we have alarming statistics. We are seeing that in the age range of physical abuse of victims, as it relates to children, because remember, what we're dealing with in the schedule now are those offenses against children. Minors, employees, boys, girls, all under 18. The Children's Authority tells us statistically 2.1% of the abuse occurred to children in the age group 0 to 11 months. 2.1%. In the age group 1 to 3, babies, 13.9% of the figure is abuse of babies in the zone 1 to 3 years. 4 to 6 years, the percentage is 18.9% of the abusers. In the age group 7 to 9, 19.6%. In the age group 10 to 13, 24.1%. 14 to 15, 13.6%, 16 to 17, 7.7%. What does that tell us? There are some very sick people amongst us in Trinidad and Tobago. That's what these statistics tell us. Let's get to what happened. Trinidad and Tobago is certainly in the position, when we look to the birth of the Sex Offenders Registry in the year 2000, under that Part 3, in the period, the year 2000 to 2019, number of persons convicted at the magistracy, let me repeat this, number of persons convicted, not charged, 1,461 convicted. Number of persons convicted at the High Court, 232, for a total of 1,693 people convicted for sexual offenses. Number of persons ordered to register in the Sex Offenders Registry, in the magistracy, 0. In the High Court, 0. for a total of 0. Following upon this government's insistent work pattern to protect children in particular, it's now a matter of record. We passed the Family and Children Division Act. We amended 19 laws in the 5th schedule there. We passed the Miscellaneous Provisions Act. We amended 23 laws to treat with children and families and women in particular. We birthed the regulations for child rehabilitation centers, for children's homes. We opened, for the first time in this country, children's courts. Faizabad, Port of Spain. We opened Tobago. We opened the family court in Tobago. We are going to be opening a family court in San Fernando. And we are expanding the family court in Port of Spain. That demonstrates a need to constantly pay attention to the work that we're doing. So, as Attorney General, in recommending to the Cabinet the proclamation of the Sexual Offences Act, because this government has taken a very dedicated step not only to pass law but to operationalize law. It's now well known: plea bargaining, criminal proceedings rules, criminal division, family and children division, proceeds of crime, money laundering. We have operationalized the vast majority of our laws and are well on our way to operationalizing all of them. In advocating for the proclamation of the launch of the Sex Offenders Register, we did a scrub of all of the litigation matters in the courts, and what we noticed is the Interpretation Act specifically preserves a charge before a court once repealed. Let me explain that. If today we repeal a law and you're charged for that law and you have a matter going in court, that is still a valid matter under a law which was validly passed. So matters which concerned offenses, charges, trials for an offense against Section 6, 7, 8, 10, 11, and 21 of the Sexual Offences Act, those sections which were repealed in 2012, persons who were facing charges and in trials for those matters still lawfully in gear. We launched the Sex Offenders Registry. The Commissioner of Police, under the amendments to the Sexual Offences Act, has the authority to publish that. Under the Sexual Offences Act, when you get to the new Part 4, which we inserted to create the operationalization of the National Sex Offenders Register, and you start at sections 45 and you move your way forward, you only go on to the National Sex Offenders Register if a court says that you are to go on the register. In other words then, there's no automatic entry. A court says that you must be put onto the register. We had the benefit of a special select committee of this Senate, which went to work at this law. When we did the amendments in that special select committee, we met with a number of stakeholders, and the stakeholders were adamant that the government was overreaching on a few issues. What were we overreaching on? We wanted to put a stamp in your passport if you're a child sex offender. We wanted sex offenders from other jurisdictions who entered the country to be subjected to this law. We wanted a certain amount of reach into people who were convicted that we put you on the register automatically. We were compelled to abandon the first two, so foreigners no longer go onto our register. We were compelled to ensure, and I think prudently so, I think the Senate did good work on that occasion, that we bear in mind the balance of rights issues as it relates to, for instance, the issue of incest. Do you really want to put the offender in incest where the family has issues to sort out? Now, we had a different approach to that. I think we ended up with a good bill, which became a good act. But what we did not spot as a special select committee is that we omitted to include the repealed offenses on the schedule. So what are we here today to do? We're here to put on to the schedule to the Sexual Offences Act. We are here to put onto the schedule those offences in Schedule 1 which are determined to be registrable offences. That's pursuant to Section 2. A registrable offense is something which a court can say you ought to, if the court gives permission, be put onto the public register. You'll certainly go on the private register, but the court will decide if it's made public. What do we have? In Schedule 1, we divided it into Part A, B, C, and we listed out all of the offenses under the Sexual Offences Act. You'll see it at Schedule 1. We listed out the offenses under the Trafficking in Persons Act. We listed out the offenses under the Children's Act. What was not listed here was the repealed offenses. So when we went to proclamation, we went to the court in due diligence fashion for proclamation. We observed that there were still existing matters under the laws which were repealed, and therefore what we do today is we come to this Honorable Senate and we ask Honorable Senators who have turned up frontline warriors all to do the people's business today, albeit in different arrangements of seating. We have asked Honorable Senators to consider amending the schedule so that if somebody has a matter that comes up at the court and the judge says you're guilty, that there's now an opportunity to register that sex offender. That's all. But the importance of it is obviously critical, because in creating a deterrent to the commission of crime, in creating a public awareness of dangerous people in our country, so deemed to be dangerous by due process in a court of law, having the opportunity by way of appeal to stop reporting, by way of appeal to not go on to the register, and by appeal I mean the aspects by which you may approach a high court or a court of appeal judge, as we amended the law to say, look, I ought not to be on the register. We're reversing that burden in the bill which we passed and amended the section of the Sexual Offences Act by. Our society is grappling with a number of issues. It's safe to say crime is number one. Right there alongside its twin, which is the economy. The twin of the economy requires us to think outside the box, to find solutions. Ugly words like taxation are critically important to Trinidad and Tobago today. As critically important as it is to make sure sex offenders are managed with due process, transparency, but with some force of law behind it. We're in trying times. Locally, regionally, internationally. We're dealing with a pandemic. The business of the country must go on. Because the one thing that we do know, there's a degree of temporariness to it all. On the pandemic side, the herd cure will come in, will flatten the curve, as everybody now knows by Google what that means, and thanks to a brilliant degree of communication from the Minister of Health, who's, I would like to say publicly today, whom I wish to congratulate in glowing terms, along with my honorable colleagues and honorable members of society in the wider sense that have leaned in to find good measure. The temporariness must be factored by the near surety that nobody could ever do away with crime. Rape has existed since day one. It will continue to exist. Evil mutates. We in this Parliament, under Section 53 of the Constitution, we can make laws for the peace, order, and good governance. We turn up to do our duty as to our part, the same way others do their part, commendably so. So today, we agreed that any amendment to the schedule should come by way of affirmative resolution. Now you're understanding why I, as Attorney General, always resist affirmative resolution. You have to move a whole sitting of Parliament to amend the schedule. We could have done it by way of negative resolution, done the order, and then anybody who had a point of view could have moved to negative the regulations or the amendments by way of schedule. That's a by far more simple approach to adopt rather than affirmative resolution, most respectfully. Because we could have done this last week. There was no agreement to do it last week. So if a matter fell through the cracks because we didn't move in time, we agreed to affirmative resolution. I spoke to my good friend Senator Mark, urging him on the last occasion for us to do this. He correctly pointed out that there was no notice for it, but you know, sometimes we could agree to agree as opposed to disagree. Sometimes we could agree to take the extra step. So here we are a week later, doing something which we could have done by negative resolution. Most respectfully, I respect the wishes of the Senate. Don't get me wrong, these are my personal views. I make no complaint about those aspects. So this is A, amend the schedule to include the offences which were repealed because they're still existing matters which are lawfully on the books of Trinidad and Tobago in terms of prosecution, so saved by the Interpretation Act. B, it is to allow for the population of the sex offenders registry by order of the court as to private and public matters. C, it is to allow the Commissioner of Police to continue the fight of crime, fighting initiatives by way of deterrence mechanisms and by way of precautionary mechanisms. Who are you hiring at home? Who are you hiring in the school? Who are you hiring at your early childhood daycare center? Who's looking after the most vulnerable in our society? This allows you a degree of transparency to know a little bit more about who you should be careful about. There's due process, there's positioning. I genuinely think that this ought not to complicate our matters too significantly, and I beg to move.
Honourable Senators, I will now propose the question for debate. The question is, whereas it is provided by Section 67(1) of the Sexual Offences Act, Chapter 1128, hereinafter referred to as the Act, that the Minister may, by order, amend Schedule 1. And whereas it is provided by the said Section 67(1) of the Act, that every order made under this section shall be subject to affirmative resolution of Parliament. And whereas a Sexual Offences Amendment to Schedule 1 Order 2020 was made by the Minister under Section 67(1) of the Act on the 26th day of February 2020. And whereas it is expedient to approve the said order, be it resolved that the Sexual Offences Amendment to Schedule 1 Order 2020 be approved. Senator Hosein.
Thank you very much, Madam President, for giving me the opportunity to rise in this august chamber to contribute to a very important piece of legislation that we are about to pass, which is the Sexual Offences Order. And Madam President, like the Attorney General, I would ask you to permit me to just thank all of those persons who right now are fighting for our country, those doctors and those nurses and those medical staff in the front line, Madam President, with respect to this pandemic of COVID-19. And those families who have been affected, those confirmed cases, our thoughts and our prayers are with them and their families, Madam President, at this time. Now, Madam President, I agree with the Attorney General that notwithstanding that we are in very trying circumstances and we are in unusual circumstances, the work must go on. But while the work goes on, Madam President, we must be cognizant and we must take the necessary precautions to protect our citizens of Trinidad and Tobago. We must exercise restraint and we must exercise precaution, Madam President. Just this morning, I would have received communication via email from the Law Association, where currently the judiciary has taken a decision whereby courts will be closed having regard to the COVID-19 situation, save and except for urgent and emergency sittings, Madam President. And that is one of the things that we have to be cognizant about when we are in these circumstances, that while the work must go on, we must protect our valuable assets, our citizens of the Republic of Trinidad and Tobago. And I heard the Attorney General indicate some level of quarrel with respect to the affirmative resolution for the passage of this order in this Parliament. But, Madam President, we are very consistent with respect to our arguments when we insist that certain pieces of legislation must be subject to affirmative resolution. Because what does that do, Madam President? It offers some level of participation by both houses of Parliament in order to pass the legislation that has gone before. It is not simply a situation whereby we can just pass legislation and allow the executive to do whatever they like. We must still have some level of contribution and some level of input with respect to carrying this piece of legislation forward. And today that is what we are doing, that you are giving this Parliament an opportunity to debate a very important matter, because this matter with respect to placing persons on a sex offenders registry is of serious and significant concern. Because when you remember this bill was introduced in the Parliament in 2019, you'd have remembered how many NGOs and how many stakeholders would have come out and give their public opinion with respect to this registry, because it's a very controversial issue. Coming from that, a special select committee of the Senate was convened, comprised members of the government, members of the opposition, and members of the independent bench, whereby this Senate was able to take a decision to agree on what is the final act, which is the Sex Offenders Amendment Act of 2019. And that act would have amended the Sexual Offences Act, the Parent Act. And, Madam President, what we are doing today is very simple in terms of what the Attorney General has presented to the Senate. Notwithstanding, he may have used a lot of words and a lot of examples, it's a very simple amendment that we are going to bring to the Senate for consideration. And that deals with capturing offenses that were repealed in 2012, so now that they are applicable to the Sex Offenders Registry. But we must contextualize how this is going to operate. The Attorney General gave some statistics, and those statistics are very frightening, because clearly it shows that in Trinidad and Tobago, our young people, our children, are at risk of sexual predators and sexual offenders. Because if you may allow me to quote from an article in the Trinidad Guardian, dated 20th of November 2018, it is headlined 16,000 cases. 16,000 cases before the Children's Authority. And this comes 3.5 years after the operation of the Children's Authority. So you can imagine how frightening a situation it is in Trinidad and Tobago today, where children are the victims of sexual offenses in this country, Madam President. It is extremely frightening. And the article goes on to say that the number of reports of child sexual abuse and sexual offenses against children over the period amounted to 5,737 cases. Oh gosh, man, this cannot be our beautiful Trinidad and Tobago. One case is far too many in this country, Madam President. There's far too many. And what this particular order is going to do is that the Attorney General was right when he piloted the order, is that in the year 2012, when the Children's Act was introduced in Trinidad and Tobago, Act 12 of 2012, it also repealed offenses relating to children that were present in the Sexual Offences Act. So it amended that particular act and it migrated offenses under the Children's Act. So now you bring all of those offenses and all of those matters relating to children under one piece of law, which is the Children's Act, Children's Act, the Act of 2012. But look at the offenses that we are now trying to place on the register. We're putting offenses on the register: sexual intercourse with female under 14 years, sexual intercourse with female between 14 and 16 years, sexual intercourse with male under 16 years, sexual intercourse with adopted minor, etc., sexual intercourse with minor employee, and householder, etc., permitting defilement of a minor under 16 years of age. Very, very serious offenses that were not captured under the 2019 amendment. And the Attorney General will always say that the opposition does not support his legislation, that we are unpatriotic, but Madam President, we are lending our support in these circumstances because we too want to ensure that the children of this country are properly protected, Madam President. And what does this order do now in terms of Section 45 of the Amendment Act? Section 45 is what sets up the registry. This is found in the 2019 amendment to the Sexual Offences Act. And if you would permit me to read, Madam President, Section 45 states that this part applies to a sex offender who is a citizen of Trinidad and Tobago or a resident. So two categories of person who was convicted of a registrable offense by a court within or outside Trinidad and Tobago on or after the 25th of September 2000, and who has completed his sentence before the commencement of this part, so that means it operates retroactively, or has not completed his sentence before the commencement of this part. So, Madam President, what we're doing now is that we're making all of these offenses that are present in the order that I just listed out as registrable offenses. It's very simple. Because the Attorney General was right in terms of saying that there may be cases that may fall through the crack. And we agree with that. Because we don't want these persons who commit such heinous acts to not end up on the registry. Now, the 25th of September 2000 is an important date because that was the date in which the first registry was set up under the 2000 amendment to the Sexual Offences Act. But what this legislation, what it intends to do is this, and I want to just be very clear, and I would just ask the Attorney General for some clarification in his winding up with respect to one particular issue, and I will raise it in a few minutes. So what we are doing now is that there are persons who may have been charged pre-2012 when the offenses were repealed, but has not yet been convicted because they are still awaiting a trial. So we want to capture those. That's the first one. Then there are those who may have been convicted prior to 2012, but after September 2000, we also want to capture those. So the question I want to ask the Attorney General is this. It is that those persons who have served a sentence prior to the commencement of the establishment of this new registry in 2019, what will be their position? Because a person does not automatically end up on the registry on conviction. The court maintains a discretion to determine whether or not an offender, a person who is convicted of an offense that is registrable, ends up on the registry. So those persons who have already been convicted and served their sentence between September 2000 to 2019, what is their position? Is it that we are going to look for these persons and then make the application before the court for them to go before the registry because they have already been sentenced? I can understand what will happen in the case coming post-2019 that are yet to be tried and convicted and sentenced. That is a very simple matter. The court maintains the discretion there to determine whether or not those persons would end up on the registry. So that is the two issues with respect to what I see here. And Madam President, this, as I said, is a very simple matter. There is not much we can debate on this matter, except to say that on this side, we have always ensured that we stand on the side for the protection of children. The Attorney General did indicate that we have the Children's Court that is up and running, and we're happy for this. But the Attorney General also does not like to inform the Honorable Senate that the Children's Court was actually something that started under the People's Partnership government, and that the UNDP was instrumental in terms of the establishment of the Children's Court in this country. What the Attorney General doesn't like to tell us also is that under a People's Partnership government was the establishment of the very important body called the Children's Authority of Trinidad and Tobago. That, Madam President, is one of the greatest achievements of our government. And we on this side, Madam President, are proud to have a political leader in the person of Kamala Prasad-Bicester, Senior Counsel, the member for Siparia, who has always stood on the side of children. Because on the very first day, the very first cabinet note that was passed by this People's Partnership government was the establishment of the Children's Life Fund, and I commend her, Madam President. So this brings me to the end of my contribution, Madam President. We on the side, we support this particular order, and I thank you very much.
Senator Richards.
Thank you, Madam President, for recognizing me. To make what I hope will be a short contribution to this motion. Before I do, by your leave, I'd just like to say a few words on what we are facing as a country. And in these types of circumstances, the situation locally, regionally, and internationally really, and with specific reference to Trinidad and Tobago, calls for us to unite. And it calls for a different kind of leadership that unites us with our commonalities and against this deadly enemy, the COVID-19. And misinformation and fake news can be equally as deadly as the virus itself. So we need to be responsible as citizens. We need to put aside our differences for our country, because division will, if we're divided, we will fall. Together, I believe we can and will overcome, and this is a time for us to show who we are as a country. Madam President, this motion piloted by the Attorney General is a very important one. And interestingly enough, it coincides, and I fully support it, with a bit of research and piece I was doing for an online portal called ISO Media and Power 10219, which is titled, because I was able to get some data from CAPA, the Crime and Analysis Unit of the TTPS, for a piece I was doing called Trinidad and Tobago's Sexual Violence Problem. So CAPA was able to very efficiently forward some data that I asked for related to rapes between the years 2000 and 2019 over a 20-year span. And what came back to me was shocking in many ways, disgusting, and it begs support for this kind of motion in many different ways. And I'll just present some of the findings in the expose. Between 2000 and 2019, there were 6,047 reported rapes in Trinidad and Tobago. 6,047 reported rapes, with 73.2% of these rapes, which is almost three-quarters, between the ages of 7 to 24. 48.7% of these rapes were between the ages of 7 to 17, which means we have a problem in Trinidad and Tobago, a significant problem, and there are predators and rapists roaming our streets in Trinidad and Tobago. Juxtaposed against the number of convictions over the same period, which were totaled 1,455, which was 24.1% of the reported rapes. And if you do research in rapes and sexual violence in any jurisdiction, you know that reported rapes fall between 50%, or in some instances 63% of those rapes or sexual crimes are unreported. So you can easily double, and in some cases, some criminologists suggest multiply the number of reported rapes by as much as 5 or 6 to get an accurate picture, which paints an even more dire and frightening picture in Trinidad and Tobago about what is happening. And it also speaks to inadequacies in the criminal justice system, and that's why it is very easy for me to support these types of motions and legislation that tighten the criminal justice system's hold and ability to protect particularly young boys and girls and women. In this case, the rapes went way into the older age groups and older demographics. It is really sad that this is happening in our country. And when you look at it, 7 to 15 age group, there were 2,042 rapes, which comprised 33.8%. And in the 16 to 17 category, 904 rapes reported, I'm saying here, which means you can easily double this to get a sense of what is happening, 14.9%. And in the 18 to 24, 24.7%. So as I said before, in the 7 to 24, that was almost 3/4 or 75% of the rapes that are taking place. And this type of criminality is extremely heinous. I was able to solicit some professional information from my colleague on the bench, Senator Dr. Dayal Singh, as a psychologist who no doubt counsels many of these victims. And I quote Senator Dayal Singh, sorry. Rape itself warps and corrupts one of the most intimate forms of human action, and as such has a unique likelihood in the survivor. Rape, to put it quite bluntly, linked to a sex act that is usually linked to pleasure, relationship, and choice. Psychotherapist Lawrence Miller referred to sex within the notion no other physical encounter between human beings carries such a desperate potential for good or evil. In rape, all positive aspects associated with sex are stripped. Rape leaves a survivor with emotional, psychological, and physical reaction. And most survivors feel a great sense of guilt and self-blame. It damages them for the rest of their lives. So I thank Senator Dayal Singh for that. And when you think of around the world, girls and women between the ages of 16 and 19 are 4 times more likely than girls and women in any other age group to be raped. And 94% of victims of sexual crimes experience symptoms including PTSD, post-traumatic stress disorder, during 2 weeks and thereafter following the rape. 30% of women and girls report PTSD 9 months after the rape. 33% of women and girls who are raped contemplate suicide. It so destroys their sense of self and well-being. And 30% of women and girls who are raped actually attempt suicide. So we really have to do more as a country to protect our girls and women in particular. That doesn't diminish in any way protecting boys and some men who are also victims of rape and sexual violence. And we also have to look at what's happening around the world. And I think when you think of the categories that the Attorney General proffered as to become in this motion eligible for the registry, I think it's extremely easy to approve it. We have to look at the college campus issue, because 25% of college women and 15% of college men are victims of forced sex during their time in college. And this is data that's consistent around the world, so we can't bury our heads in the sand and think it's not happening in Trinidad and Tobago. So we really need to look at sexual violence, rape, with a different kind of eye, given the statistics coming out and some of the statistics that I've been able to outline today, particularly in the context of those statistics of occurrences or reported occurrences juxtaposed against the level of convictions and the fact that in many cases, persons who are in fact repeat offenders, the public has no way of identifying them as repeat offenders, and the dangers, the significant danger they pose coming back into society with a predilection for repeating these heinous acts. So I fully support these provisions in this motion, and I thank the Attorney General for proffering them today. Thank you, Madam President.
Senator Ameen.
Thank you very much, Madam President. I rise on this occasion, and I want to, like the members before me, take the opportunity to acknowledge the fact that the Senate is sitting during a time when the government has asked this country to desist from all social gatherings except
all right,
those
Senator Ameen, I think I have to intervene here. Prior to this, and put on the record that just prior to this sitting, there was a meeting with the leader of government business, the leader of opposition business, the coordinator of the independent bench. And certain things were discussed, and I would ask you and all other speakers to desist from the line that you're now going down, okay?
Well, thank you, Madam President. I'm not sure I'd established the line I was going on. I wanted to join
Senator Ameen, yes. Take it from me. I know the line that you were going down, and I am asking, please, that you move on immediately to the points that you have to make on this matter at hand.
Thank you, Madam President. Madam President, I just want to take this opportunity to record that contrary to some of the points raised by the Attorney General, whether he said it explicitly or not, that the United National Congress stands in support of protection of women and children against sexual violence. Trinidad and Tobago became a signatory to the United Nations Charter on Children's Rights. And the UNC and People's Partnership governments, led by Prime Minister Bastio Pandey and Prime Minister Kamla Persad-Bissessar, brought a number of pieces of legislation to this Parliament to establish the protection of the rights of children. My colleague before me mentioned the establishment of the Children's Authority. The Attorney General indicated that he had the opportunity to work with the government, the then government when he was in opposition, to ensure that the legislation was passed, especially where it required a special majority. And Madam President, that has been the difference in the approach between the different governments. I have sat here and experienced occasions when the government, if they feel they will not get the support of the opposition, would make moves to remove that requirement for a special majority, which I've said before and I repeat, is dangerous to democracy. We are in a situation today where the opposition and the government is in agreement with the measure being brought. I know the Attorney General has indicated on numerous occasions he's not really in favor of having positive resolutions because it does require us to come back to Parliament. It does require a sitting to convene to agree on something that may simply be agreed to automatically. But I do believe, Madam President, that having a positive resolution allows for ventilation, allows for input, and allows for the Parliament to take into consideration any change in circumstances. And that is not applied to this piece of legislation alone. It applies across the board. And I am in full support of having greater transparency and greater participation. Madam President, what I would like to raise at this time is the rate of conviction, the poor rate of conviction of sexual offenses in general and sexual offenses against children in the courts of Trinidad and Tobago. I am certain that just as the statistics are available with regards to arrests versus conviction, I am certain that data is also available to the state and to the relevant authorities with regards to the factors that cause our rate of conviction to be in the vicinity of 20%. We have to also bear in mind that not all sexual offenses that take place are actually reported. Not all that are actually reported end up with a person being charged. And certainly not all persons charged end up being convicted. And justice for the society and justice for the victim should be of paramount importance. We, as a state, have to begin to examine the factors that cause low conviction rates when it comes to sexual offenses. I don't want to, I do have some information. I don't want to go into it at this time because I get the impression that we want this sitting to be brief. But Madam President, there is a lot of literature available in terms of why conviction rates are so low. Madam President, I want to take this opportunity to urge the Attorney General, the division in the Office of the Prime Minister responsible for children and gender, which I think should be a ministry of its own, and the NGOs, to come together to make these recommendations to the judiciary, to the police, to the DPP's office, so that the rate of conviction of sexual offenders could be improved. I also, Madam President, in the interest of justice, want to stress the importance of, well, I don't want to say mediation, because I don't think this is one of the cases where you want to really have mediation per se, but certainly counseling. Counseling for the victims, the families, as well as the perpetrators and their families. Very often, the perpetrator or the accused is vilified. You have a lot of stigma attached to rape and sexual offenses. What we often do not take into consideration is the innocent relatives of the alleged attacker or alleged perpetrator. And I feel that there is space in our court system to deal with that. The victims and the victim's family, as well as a support network, should also get that support from our courts. Sexual offenses is not one of those crimes where I feel that we should only take the hard approach when it comes to prosecution, when it comes to finding victims and perpetrators, and when it comes to sentencing and bringing justice. This measure, to have a positive resolution, Madam President, may be very small today. However, I am of the firm belief that when the time comes around for this matter to come back to Parliament, if it is necessary, if the minister finds it necessary to make adjustments, it leaves room for every one of us and every person who will be in this Parliament at that time to make a contribution to improve the legislation and improve our protection against, or protection for those who are victims of sexual offenses. So, Madam President, I am in support of having a positive resolution to the regulations. I am in support of Trinidad and Tobago putting firmer measures in place to protect victims of sexual abuse, and the actions we take in law, in the court, and in other spaces must send a strong message to influence our culture in terms of how we treat with sexual offenses, how we treat with rape, how we treat with incest in particular, that happens within the home that is supposed to be a protected space. And Madam President, maybe this is the opportunity for us to ventilate some of those things. So I know that there are people who would have traveled recently and think I am not looking forward to staying in much closed spaces. I really intend to make a short contribution today, but I am strongly in support of this particular measure that is brought. Thank you, Madam President.
Senator Vieira.
Thank you, Madam President. Madam President, this motion seeks to amend Schedule 1 of the Sexual Offences Act by adding to the list of registrable offences persons convicted of sexual intercourse with children and householders permitting defilement of minors under 16 years of age, or employers who have sexual intercourse with minor employees. Given that the subject matter of the motion relates to the discouragement of sexual predators by naming and shaming potential offenders, I expect this motion will have full support of the Senate. But I rise to speak because I think this is also a very timely motion in that it provides a good opportunity to see how affirmative resolutions operate in practice. It's relevant because in the Revenue Authority bill, which is also under consideration for debate at this moment, there are two clauses, clauses 13 and 15, where affirmative resolution features, and that is in relation to the minister's powers of appointment and revocation of appointment of the board to the Revenue Authority. So this is a good opportunity to see how affirmative reaction plays out. Affirmative resolution. Thank you, Senator Hosein. According to Section 75(5) of the Interpretation Act, the expression subject to affirmative resolution of Parliament, when used in relation to any statutory instruments or document, means that those instruments or documents shall not come into operation unless and until affirmed by a resolution of each House of Parliament. So unless this order amending Schedule 1 of the Sexual Offences Act is affirmed, the offences identified in the motion remain inoperative. So the long and short of it, Madam President, is affirmative resolutions are a means whereby Parliament retains a measure of control over the exercise of power. I think they are an important tool in the democratic process. They are a mechanism for transparency and buy-in. I thank you.
Thank you very much, Madam President. Yeah, Madam President, this particular motion, which seeks our approval to address an amendment to the Sexual Offences Act by amending Schedule 1 and manifested through an order that we have before us, amending the very schedule, is one, Madam President, that we on this side associate with and will give support to. I want to say, Madam President, that we in the United National Congress have had a very proud history and a very proud record of not only promoting children's legislation, but consolidating and operationalizing those pieces of legislation. Madam President, whether it had to do with the package of legislation affecting our children, which remained literally in abeyance for several years until we, in the period 1995 to 2000, under the administration of the Honorable Basdio Pandey, and through the leadership of the Office of the Attorney General, Ramesh Lawrence Barrage, piloted a package of children's legislation consistent with our international obligation under the United Nations Convention on the Rights of the Child. And Madam President, you would recall that in that package of legislation that would have been debated in 1999 and passed in early 2000, among those pieces of legislation would have been the Children's Authority Act, the Children's Act, the Children's Community Residences, Foster Care, and Nurseries Act, as well as the Adoption of Children Act. And Madam President, in an effort to further consolidate and operationalize those very important pieces of legislation protecting children's rights, it took the Kamla Prasad Bissasa's administration of 2010 and 2015 to further consolidate, amend where was necessary, and to establish a committee headed by, I think, Dana Mahabir Wyatt and Stephanie Daly, among others, to fully operationalize and give effect to the children's legislation in this country. So what we have today and what we are debating today is a very important measure as it relates to further protection of our children, particularly those as outlined in the order, who may become victims of criminals and aggressors in this land. And Madam President, we saw what happened in 2019 when this Sexual Offences Act was amended and given way to a registry to deal with offenders, and giving the court of this country, through the judges, the authority to determine whether these persons should be incorporated and whether they should be publicly made available to the citizenry of this country. Madam President, in 2012, the Children's Act was passed. And as you recall, this raised the legal age for sexual consent, subject, of course, to certain exceptions, to 18 years. It is, and it must be noted, Madam President, that the exceptions would have included, Madam President, non-liability where both parties were children, and as regards sexual touching, the age of consent would have been 16 years, Madam President. Although that is still an offense for an adult, Madam President, to encourage a person under 18 years to engage in sexual touching, thus rendering effectively any sexual conduct with a child under 18 to be illegal in our country. Madam President, prior to 2012, the Sexual Offences Act included various offenses dependent on the actual age of the child, with varying legal and or evidential tests. But due to the Children's Act, those sections relative to those offenses were repealed, as we were told earlier in this debate. And that is what we are seeking to address today, Madam President. Madam President, Act number 19 of 2019, which was assented to in September, and to be precise, my date is the 26th of September 2019, the Sexual Offences Act was amended to create what is called, Madam President, the Sexual Offenders Registry, as I brought to your attention earlier. It was now required that any person, Madam President, who was convicted of a now Schedule 1 offense on or after the 25th of September 2000 was required to report to the nearest police station to have his details entered into the Sexual Offences Registry within 6 months of the passage of the Act. And Madam President, the reason why we are here today is that the 6 months deadline that the Act gave for this to take effect, today being the 17th of March, that period, Madam President, would come to an end on the 25th of March 2020. And hence the reason we are debating this measure today. I just want to indicate, Madam President, that the Attorney General, in his contribution, made a reference to his approach to my good self last week to have this matter debated last week. And of course, I did indicate to the Attorney General that we needed notice to prepare for this piece of, for this debate, I should say, only to be threatened by the Attorney General. Okay.
I do have to caution you that you're, thank you.
Only to be advised by the Attorney General that if we do not support this matter, he will make a public statement and have us in the UNC embarrassed. Now, that is a kind of bullying tactics.
Mark?
All right, I withdraw that, Madam President.
Yes, and if you continue, you will the next time, and I hope there's not a next time, you will have to withdraw and apologize. Okay?
But I need to bring to your attention what was done. Do I not? I think my language is what you're concerned about.
I am very concerned with your language, and therefore I will ask you to address that as you continue.
So what I'm saying, Madam President, is that we are not the floor cloth or the footstool of anyone. We represent close to 360 to 70,000 people in this country. And therefore, we will not be intimidated or harassed by anyone. Whether that person happens to be a direct descendant of the Prophet Muhammad or has links with Iraq. Madam President.
No, please, take your seat. There is absolutely no need to go down that path. I would ask you, please, yes.
I was just trying to respond to the Attorney General, Madam President, who began this excursion into adventurism. But, you know, I always am guided by your rulings. But, Madam President, as I said before I engaged you a short while ago, there is a deadline, Madam President, for this particular matter to be addressed. And this is why I suspect the Attorney General is trying to engage me, although he knew that March 25th is a little way from today. So we will pass it today, and he will meet his deadline so that those elements in accordance with Act 19 who were convicted would be required under the Act of 2000 to report to the nearest police station upon that 6-month period that I've mentioned. Now, Madam President, the said schedule did not take into consideration sexual offenses that were not then on the statute, meaning that the offenses that were removed by the 2012 Children's Act were not captured. And this is what the order is seeking to capture, Madam President, to ensure, as we were advised, this order, Madam President, which seeks to amend Section 61(7) of the Sexual Offences Act, would bring into being these particular offenses that would have been repealed by this Act of 2012, which is number 12 of 2012 Act. And the various offenses were listed in this order, so that, Madam President, those who were found guilty and are convicted for such heinous sexual offenses against children in our country would not escape the law that was passed in 2019. And if I may, Madam President, remind this Honorable Senate, we are talking about sexual intercourse with female under 14 years. That is Section 6 of this Act of 2012. Then, Madam President, Section 7, sexual intercourse with a female between 14 and 16 years. That is going back into the schedule, Madam President. Then Section 8, which was repealed by Act number 12 of 2012, and that is sexual intercourse with male under 16 years. Section 10, dealing with sexual intercourse with an adopted minor. Section 11, dealing with sexual intercourse with a minor employee. And the last section, Madam President, Section 21 of Act number 12 of 2012, householder permitting defilement of a minor under 16 years of age. So we want to ensure, Madam President, that these offenses find their way in this amendment to the Sexual Offences Amendment to Schedule 1 Order 2020. And that is why I'm saying, Madam President, this motion that we are debating this evening seeks to include these offenses, Madam President. So we have to recognize that there was a clear oversight in the initial drafting of the 2019 Act. And, Madam President, we have no difficulty, without going into any lengthy debate on this motion. We see no ethical difficulty in agreeing to the amendment that is before us. We know it is a matter of urgency to have this particular order approved, because there is a time limit, Madam President, for registration, which, as I indicated, will expire by the 25th of March 2020, which is a few days away, Madam President, today being March the 17th. So we're talking about a few days away to have this matter addressed and approved. And that is the reason why we are in this place today. And that is why we are debating this motion in order to avoid, Madam President, these aggressors, predators, and sexual offenders from escaping due process and from escaping the will of the Parliament as it relates, Madam President, to the amendments that were brought about as a result of our discussions and debate to the Sexual Offences Amendment Act in 2019. So I say, Madam President, we on this side have, as we have demonstrated in the past, have no objection. There is no opposition. There is no question of our unwavering support for the measure that is before us, and we are happy to be associated with this measure today, Madam President. Madam President, you know, I'm not normally short in terms of my contribution, but with your leave, I will be today. So I want to thank you very much for allowing me to make my intervention this time.
Attorney General.
Thank you, Madam President. Madam President, I thank honourable senators for their contributions. There are just a few very small points to refer to. First of all, I just genuinely cannot understand what Senator Mark was talking about. There is no time limit. There is no compelling force to bring us here to discuss this law, other than the fact that in the usual course of scrubbing preparedness for operationalization of law, proclamation of law, we at the Attorney General's office go to the repositories of information and double check what we're doing. And if there is a need to cause amendments or to fine tune, we then inform the relevant authorities, in this case the Cabinet, and therefore we take a step. I have no idea whatsoever as to what Senator Mark is talking about. He's entirely on a frolic of his own. The position raised by Senator Hosein is one that I think needs to be clarified. Senator Hosein asked a question which effectively is a logical one. What happens when we treat with the situation as to persons between 2000 and 2019, in this case 2019 when the law became subject to proclamation? We addressed that very squarely in the amendments that we caused to the Sexual Offences Act when we introduced the new Part 4 for the Sex Offenders Registry. The position is complicated. Short answer is we can do nothing. They will not go on to any public register. The Amendment Act says that in plain text. Yeah. So persons who are convicted already and who have not gone on to the register will not go on to the register. That's not to say that the police are not in an exercise right now of identifying all convictions, because I want to put into the context the fact that we are not just passing law on our team here in team government. We're operationalizing law, and we are digitizing all of the records of the judiciary, and in particular the magistracy. Senator Ameen raised the point about talking to the judiciary about improving convictions. Let me just repeat. We have over 1,600 convictions for sexual offenses, none of which are on the sex offenders registry. So coulda, woulda, shoulda, that just doesn't arise. It just wasn't done under the tenure of the last government or any other government since the year 2000. As Attorney General with responsibility on this occasion, I can tell you 1,600 convictions is a lot of convictions. The point is nobody's on the register. We established the register. We brought the law to Parliament. We created the positions. We implemented law after passage, and we opened courts. We anonymized children's records. We brought in the UN conventions. It was kind of surprising to see, Senator Hosein, that the Attorney General didn't give credit to the last government for the passage of the Children's Act. I specifically said, as an opposition senator, I supported the government. And to disagree with Senator Ameen, it isn't that the last government worked with the opposition. On the occasion of amending the Children's Act, there was no discussion by the then government. Senator Vieira was there, he remembers it. I was compelled to put 212 amendments into writing myself, because the government would not listen to a word I had to say. So I am not going to accept the reinvention of history today from Senator Ameen. That's just not the case. In my 10 years as an opposition senator, there was never a marked up bill provided. There was never a marked up act provided. There was no data as to what Trinidad and Tobago looked like ever. We now operate in a solidly different environment in this Parliament, with a published legislative agenda where all tools are provided to all members of Parliament, whether they're in opposition or government, because that's just the right thing to do. When I came in as Attorney General and I instructed the Chief Parliamentary Counsel that we will be doing what I just said, marked up bills, marked up acts, circulated amendments, and we would listen, they said, AG, are you sure you're doing the right thing? The last government's approach is that if you gave the opposition too much, they would use it against you. I said, for heaven's sake, we're not going to do that. We're going to be transparent in the passage of law. In the position of answering Senator Hosein, just to complete the record, I'd just like to point out that when we got to Section 47 of the Sexual Offences Act as we amended in this Senate and in this Parliament, the register has been created under Section 47. It's a National Sex Offenders Register. The provisions of Section 49(4)(c) apply. The information contained in the register, this is Part 4, Section 47, subsection 4, the information contained in the register referred to in Section 34(c)(2) of the former Part 3 of the Act shall form part of the register, but such information shall not be accessible to the public. What is a matter of record is that there was nothing on the register. It just wasn't done. Nobody was tracking it. Nobody was enforcing the laws. We have taken a different approach to track and enforce the laws. I want to warn people that have been convicted that the police are, in fact, together with the Judiciary and the Attorney General's office, we are going through, by way of combing, all of the records at the Judiciary, who has been convicted, who has not, and we have another way to treat with it. There's one other point to address. I want to reject out of hand, Madam Speaker, Madam President, Senator Ameen's statement that the government is dangerous to democracy because at times I, as Attorney General, have stripped 3/5 majority requirements. Let me put on the record what was done. Whenever we were faced with the usual position of the opposition, and I say opposition alone, that they will not support laws which require 3/5 majority, we have taken the step to remove the clauses in the bills which required the 3/5 majority. In other words, then, the things which offended the Constitution and the requirement for 3/5 majority, we remove those things, leaving, therefore, only the things that don't require 3/5 majority. And those have passed. We have managed to treat with it. The classic case example on that was the income tax amendment, which we had to bring to the Parliament. If you recall, December last year, or earlier last year, we were dealing with the income tax amendment. Police access to income tax information was brought together with the requirements to achieve the Global Forum requirements. The opposition refused to support it. We moved the Global Forum requirements, which, by the way, are a replica of FATCA. We put that in a separate bill. We passed the simple majority law that went into effect. Nobody has challenged it, and they can't. That which went to Joint Select Committee, which was so burning and urgent that the UNC could not support it, that was the subject of amendment in the Joint Select Committee. And in fact, we amended the bill to delete a semicolon. That was it. So I'm not taking the argument today at all, coming from the opposition, that there is anything dangerous in that approach. We will just simply shift gears when we meet a reticence on the part of certain members to give support for things which are in the national interest. This government will not be delayed by any of those delay tactics when the people of Trinidad and Tobago are suffering. That's just not what's going to happen. And every tool available in the arsenal of the Attorney General's office and in the arsenal of the government will be applied with fair measure and constitutionality for the peace, order, and good governance of this society, Madam Speaker. Madam President, forgive me. Madam President, I don't think there's anything else to answer, save that really and truly, I do still stick to the prescription that not positive resolution, as Senator Ameen calls it. That's called affirmative resolution, Senator Ameen. Affirmative resolution is as good as negative resolution. Negative resolution still has parliamentary scrutiny. You must pass it, put it on the table. It there stands for 42 days, not including recess period and time, so it may be months. And you have the option to negative whatever is brought for negative resolution, move a motion to say, I don't want that. And therefore you have parliamentary scrutiny. So let's be serious with this. Affirmative resolution is as good as negative resolution, and I rest my case. And in resting my case, I beg to move.
Honourable Senators, the question is, be it resolved that the Sexual Offences Amendment to Schedule 1 Order 2020 be approved. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The motion is therefore carried.
Second reading.
Attorney General.
Thank you, Madam President. Madam President, I beg to move that a bill entitled An Act to Amend the Constitution, Prescribed Matters Act, Chapter 102, the Interpretation Act, Chapter 301, and the Judicial and Legal Services Act, Chapter 601, be now read a second time. Madam President, what we do here today is perhaps one of the shortest pieces of law, but yet one of the most important features of law that we can deal with in terms of amendment or consideration as a parliament. Permit me, Madam President, to therefore say that this bill, which is all of 4 clauses long, and which proposes, firstly, an amendment to the Constitution Prescribed Matters Act, secondly, an amendment to the Interpretation Act, and thirdly, an amendment to the Judicial and Legal Services Act, is part of the crime-fighting maneuvers, the anti-crime measures that this government considers critical to the development of Trinidad and Tobago. As a government, Madam President, we have taken a very deliberate approach to avoiding the usual pattern of governments coming to Parliament, passing laws, turning their back on the laws, and not worrying about implementation. We just completed a bill which demonstrated that we passed a law in the year 2000, and 19 years later, 20 years later, not a single person was put on the sex offenders registry. Why? There was no conscious reflection upon the following key characteristics for success. What are they? Plant and machinery, people, processes, and then law. As Attorney General of the Republic of Trinidad and Tobago and Minister of Legal Affairs, I have approached the task of legislation with transparency but we have, as a government led by the Honorable Prime Minister, underwritten the laws by plant and machinery, people and processes. What do I mean by that? When you pass a law to deal with money laundering, plea bargaining, kidnapping, bail, whatever it may be, sexual offenses, those laws of Trinidad and Tobago have to be dealt with by people in places with processes. In the criminal justice system, the core of the criminal justice system was not the subject of proper scrutiny by governments prior. There was no meaningful appreciation of caseload and case management by the number of persons assigned to work in that system. It's now commonplace. Everybody here knows what I'm about to say. In the magistrates' court, we have 146,000 cases per year amongst 43 magistrates in 12 courts. We have 26,000 preliminary inquiry cases per year in the magistrates' court. Senator Hosein is buckling under the repetition that I give. Why? If you repeat it over and over again, it sinks into your psyche what the caseload is. And this bill is designed to treat with exactly that. Why? Who are the people in the criminal justice system? Judges, prosecutors, police officers, prisons officers, marshals, registrars, masters, defense attorneys, legal aid, support officers in the judiciary, probation officers, medical officers, etc. But how are we going to manage bringing a consequence to a crime if you don't have the capacity to treat with it? It's true that we have made massive amendments. We've created divisions of court. That never happened before. We have a family division, a children division, a civil division, a probate division. When we came into office, we had the civil proceedings rules and the maintenance rules. We now have criminal proceedings rules, family proceedings rules. Sorry, we had family proceedings rules, they were unamended. And we also have probate rules now. When we came in, case management was being done by 2 masters. Today we have 21. In a month's time we'll have 31. When we came in, statute provided for 36 High Court judges, we're now at 64. Statute provided for 12 Court of Appeal judges, we had 15. When we came in, clerks of the peace, who were unqualified attorneys, managed the legal aspects in the courts, in the magistracy. That's a feature of the past now, because we have registrars of the magistracy. When we came in, judicial officers in the magistracy worked in an uncomputerized environment. They had no support staff. There was no digital recording. That's now a feature of the past. 5-to-1 ratio to the magisterial support system. Why? They conduct the lion's share of work. When we came in, 146,000 magistrate matters. April 2nd, we'll delete 104,000 of those cases when we operationalize the Motor Vehicle and Road Traffic Matters Act. When we move to the opening of the new civil courts at Tower D, and therefore the birthing of 64 criminal courts at the Hall of Justice, we'll be able, with the DPP's consent, to operationalize the abolition of preliminary inquiries. There's another 26,000 cases gone. December 23rd, 2019, we decriminalized marijuana and 8,500 cases fell off the radar. Where does that leave us? 8,500 cases per annum amongst the same 43 magistrates in 12 courts in a computerized environment with rules of court, with sanctions that can apply. What are we doing about the officers? As a matter of record, I want to say today, public defenders are born. Who is the head of the public defenders? UNC Senator Haseen Sheikh. I take your congratulations, Senator Hosein, because this PNM Attorney General has the courage to hire a UNC Senator who sat temporarily twice as the head of the Public Defenders Division. You understand what I'm saying? In this bill, capacity in the judicial system is what we're dealing with. We, under the Constitution of the Republic of Trinidad and Tobago, Chapter 7, Sections 99 onward, have established the Supreme Court, High Court, Court of Appeal. We have the Judicial and Legal Services Commission, Sections 111 onward. We have the SRC, the Salaries Review Commission, Section 141 of the Constitution. We have Section 106 of the Constitution that says judges shall be employed on terms and conditions as may be prescribed. We have Section 111 of the Constitution which coordinates with that. We have Section 108 of the Constitution. What does all of that mean? We have Section 136 of the Constitution of the Republic of Trinidad and Tobago, equally in movement. Chapter 7, the Judicature. Section 99 establishes the Supreme Court. Section 101, the Court of Appeal. Section 106 of the Constitution, subject to Section 104.3, a judge shall hold office in accordance with Sections 136 and 137. Section 136, the holder of an office to which this subsection and subsections 3 to 11 apply shall vacate his office on attaining the age of 65 years or such other age as may be prescribed. When we get to the prescription, we turn to the Constitution Prescribed Matters Act, which this bill treats with, Chapter 102 of the Laws of Trinidad and Tobago. And in Chapter 102 of the Law of Trinidad and Tobago, we say, in Section 3, salaries and allowances of certain office holders, we apply to those in the first column in the first schedule, and we apply to those in the first schedule, holders of offices, etc. Salaries and allowances prescribed in this section shall be a charge on consolidated funds. What's the number one capacity in a courtroom that is of most critical importance? Not the judge. So we in Trinidad and Tobago have judges that retire at 65. 65 years old, our capable, hard-working judges who have an experience that the rest of the Caribbean, save for Jamaica, doesn't have. They have volume, caseload, complexity. They have incredible talent at the bar. They are tested in the fire of our hope and prayer, and they have gone to Privy Council and back in terms of judgments being reviewed. We have a robust, excellent judiciary. They retire at 65, and the other islands up the Caribbean and the Commonwealth promptly hire them. Turks and Caicos, Belize, Cayman Islands, you name it. Our judges go at 65 and then work till 75 in some instances. So we just lose capacity. It's true that we amended the law to allow now judges to come from the Commonwealth. If you recall, we had amended that law as opposed to just of the Bar of England. But now we are saying in these measures here in the first part of this bill, let us keep our talent to age 70. I personally think that 70 is a little low. That's just my personal view. I stand as a member of a cabinet that thinks that we should feel the views of society, and hence we've come with a bill today. Let's look to the experience in the rest of the Commonwealth. What do we see in the Commonwealth? We see the following jurisdictions which are of note, if I may put it onto the record. We have, in our tour of the Constitution, Australia, retirement age 70. Canada, 75. Guyana, 65. They've just amended. Jamaica, 70. United Kingdom, they've gone to 75. The United States of America, when you die, that's when you go, unless you resign. When you die, unless you resign or are removed from office, that's your age of retirement. 70, I'd like to say as I get older, 70 is the new 50. I genuinely think that. Our Constitution is robust. Our Constitution allows for removal from office for infirmity, invalidity, etc., etc. We have mechanisms to treat with what can be considered to be the effects of age and difficulty. Members are entitled to resign if they so choose. We as a government, without the opposition's support, except for Ganga Singh in the House, who had the courage to break ranks with the UNC, we as a government passed the pension improvements for the judiciary. Why? Not only to take care of the indignity that judges were suffering, those who had retired for a long time ago and were receiving not enough care, but to make the attractiveness of office there so we could retain talent. As Attorney General, I have invited the Chief Justice to remove the 10-year limitation under the Legal Profession Act, as the Chief Justice can, down to 3 years. Why? We need temporary judges who can act as permanent judges, and the restriction of 10 years you can't practice if you become a permanent judge is not opposite to our best interests, particularly in the glorious intellectual inconsistency of a temporary judge serving, coming off the bench and going back into practice immediately. I mean, that's just not on. So in treating with judicial capacity, we are saying today, let us amend the Constitution Prescribed Matters Act. Let us amend the Judicial and Legal Services Act. Let us move the age from 65 to 70. If we need to think about it again, we can always come back and move that age. No problems. That's part one of what we're doing in clauses 2 to 4. Part 2 of what we're doing is critically important, and it is rooted in the Judicial and Legal Services Act. In the Judicial and Legal Services Act, Madam President, what we're doing, we are treating with the elephant in the room. That's what we're doing. This country, I dare say, is the victim of its own constitution, depending upon how you look at it. And I mean this in a very carefully, intellectually constructed position. We have in our Constitution certain safeguards which I adhere to. One of our safeguards is our service commissions. I'm going to do what I do in many other places, and I'm going to say, if anybody in this room right now could name the head of all of the service commissions in Trinidad and Tobago, I will give way now. Silence. Why? We are all, I'm a member of the House, everybody else here is a member of the Senate, and nobody in this House, this Senate today, including me, could name the chairman of the service commissions. Why? They are nameless and faceless, their caseload is not known, they're constitutionally separated. And one of the features of lacking in performance in Trinidad and Tobago is the Salaries Review Commission. For heaven's sake, Section 141 of the Constitution says the Salaries Review Commission shall adjust salaries from time to time. Well, they on an exercise for the last 30 years. They can't finish. Millions of dollars spent in reviewing terms and conditions. We constantly talk to Singapore and how great they perform. We're paying peanuts. We're not holding people accountable, and we want to know why things are working. That is anchored to this bill as well, because the Salaries Review Commission has refused and or failed to review the salaries of the Chief Magistrate, the Masters of the Court, the Executive Court Administrator, and the registrars. These are the key linchpins to performance, and right now they are paid less than a permanent secretary. The chief magistrate running the whole magistrates court. The registrars running the administration a la permanent secretary style. The executive court administrator is the person as a receiver under the Exchequer and Audit Act as a permanent secretary for the judiciary. And we are paying these office holders less than what is required, less than the Chief Parliamentary Counsel, less than the DPP, and less than the Solicitor General. And in the face of the SRC not making a recommendation to Parliament, to Cabinet, and remember, the SRC makes a recommendation which the Cabinet can reject, consider, or do something else with, right? There is the legislative and constitutional ability for this Parliament to adjust the salaries. Are we within parameters? I invite members to look at the Judicial and Legal Services Act, Chapter 601. I look at Section 15 of that Act. Subject to the Constitution and any written law, control and supervision may be exercised over A, Masters of the High Court, Chief Magistrate, Registrar of the Marshal, by the Chief Justice. We're amending that. We're saying delete those words, insert instead a Chief Judicial Officer. Who is a Chief Judicial Officer? We're adding that into the definition section. Here who the Chief Judicial Officer is. The same Master, Chief Magistrate, Registrar and Marshal, and Chief Justice. Sorry. And now adding in Executive Court Administrator. Stick a pin. I think we need to do a small amendment because the term of Registrar needs to now be adjusted. Because we did the criminal division, family division, we did some adjustments there. So, we are simply adding in the Executive Court Administrator into this. Stick a pin. Again, turn to the second schedule. You'll see Judicial Offices, Part 1, Part 2, Part 3, Part 4, Part 5. You will note in Part 3 that the Court Executive Administrator falls under the Chief Justice anyway. So all that we are doing is harmonizing what is in the second schedule with our definitions clause. So, legitimate aim number 1 in the bill is amend the Constitution Prescribed Matters Act, change age of retirement from 65 to 70, springboarding from Section 106 of the Constitution and Section 136 of the Constitution. Legitimate aim number 2, amend the provisions of Section 15 of the Judicial and Legal Services Commission Act, Judicial and Legal Services Act, forgive me. Delete the reference to the several officers in Section 15, replace with the definition of Chief Judicial Officer. Chief Judicial Officer now captures one more body, that's the Executive Court Administrator, that is set out in the second schedule, Part 3. That's legitimate aim number 2 of the legislation. I want to, for the record and for the purposes of underwriting constitutionality again, remind that it was in the year 2003 that the public service was divided in its administration by the judicial administrative arm, hence judicial officers, and by the executive arm or government arm, which is the other public officers. You have officers that are officers and contract officers. So all that we are doing is we are improving the landscape and clarity of the law. What's legitimate aim number 3 of this bill? Legitimate aim number 3 of this bill is anchored in clause 3. That is the ubiquitous Section 63 of the Interpretation Act. I've referred to Section 63 of the Interpretation Act on so many occasions that I'm sure everybody knows what it is. Laws are primary or secondary, subsidiary. A regulation is a subsidiary legislative product. If you breach a regulation or a subsidiary product of law, unless the parent act, which allows you to create regulation, says what the offense for breach of a regulation is going to be, the Interpretation Act kicks in. If you create a parent law, you say that somebody has the power to create a regulation, and you don't say what a breach of a regulation equals, Section 63 of the Interpretation Act kicks in, and you get subjected to a whopping $500 penalty. That is why on umpteen occasions I've come to the Parliament and said, notwithstanding Section 63 of the Interpretation Act, a breach of the regulations shall amount to summary, indictable, we put a dollar figure, we put a jail term, so that the regs can bite. Where are regs important? By way of example, the securities industry. We capped regs at $500,000, and recently we had some complaint about certain things as to the cap and ceiling. The point is you need to treat with it. So we are saying in this law here, in our bill, let's change Section 63 of the Interpretation Act. Let us say, delete the word 500 and substitute the words $100,000 and a term of imprisonment not exceeding 5 years. I remind those are expressions of maximum range. The judiciary has the discretion as to what you will get. That may be a reprimand and discharge. That may be $0. You may get community service. Whatever the judiciary in its discretion chooses to offer as a sentence is what you get. This is just the maximum ceiling. We no longer in law use the expression of maximum or minimum indication because the Privy Council has frowned on certain aspects of that. So, Clause 2, Clause 1 is the name of the bill. Clause 2, the Constitution Prescribed Matters Act, that's the effect of raising the judicial age, 65 to 70. Clause 3, we're fixing Section 63 of the Interpretation Act. Clause 4, we're amending the Judicial and Legal Services Act. We're adding in a definition of Chief Judicial Officer. That definition is Chief Magistrate, Registrar and Marshal, Court Executive Administrator. We're amending Section 15 of the Judicial and Legal Services Act. We're substituting the words in 1A by Chief Judicial Officer, so defined. And we are saying that the terms and conditions of service of Chief Judicial Officers shall be those equivalent to Chief Legal Officers. Who are Chief Legal Officers? DPP, Chief Parliamentary Counsel, and Solicitor General. We are therefore equating the salary ranges for these officers to other officers that are known to us. It's the difference between L1 and J1 categories in the public service speak for the record, and all that we are doing is improving their terms and conditions to what the SRC really ought to be considering, but just can't finish considering. Maybe they need another 30 years. I don't know. I just don't know how to explain that. It's been the subject of serious interrogation by many governments, and it's time that we just press on with the work. In summary, therefore, Madam President, this law is designed to integrate in the anti-crime plan of the government. It is designed to preserve capacity in the performing aspects of the criminal justice system. Keep our talent, preserve their rights, equivalent and pay terms and conditions equal to standing officers who are well known, who handle functionalities that are as important as, sometimes less heavy than, what certainly the Court Executive Administrator does, the Chief Magistrate, the Masters, etc. We're just fixing those aspects. It gives me great pleasure to promote this bill, and I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Constitution, Prescribed Matters Act, Chapter 102, the Interpretation Act, Chapter 301, and the Judicial and Legal Service Act, Chapter 601, be now read a second time. Senator Sobers.
Thank you, Madam President, for recognizing me this afternoon and for giving me an opportunity to contribute this afternoon on an act to amend the Constitution, Prescribed Matters Act, Chapter 102, the Interpretation Act, Chapter 301, and the Judicial and Legal Services Act, Chapter 601. Madam President, let me indicate that in principle as it is right now, we here on the side of the opposition definitely do not have any objection whatsoever with respect to the essence of this particular bill. I think many of us who practice within the criminal justice system or who are lawyers by profession understand and appreciate the vast amount of talent that we have sitting on our bench. But we must also understand and appreciate what systems they operate within at this current stage that would attract them to leave our shores. And it is a welcome approach to put measures in place that could keep them tethered to Trinidad and Tobago and continue to lend and assist in terms of their intellectual resource in the advancement of jurisprudence within our country. But I would also just want to touch on a couple things that was raised by the Honorable Attorney General in piloting this particular bill. And I don't intend at all to be lengthy with respect to this bill, because I agree, although it's just 4 clauses long, there's a bit of depth to it that we should explore, and I think other members of the chamber would do so as well. The Honorable Attorney General indicated that in terms of the approach of the administration, this current administration, they would look at plant and machinery, process and people. And I agree in terms of an holistic approach to treating with legislation and even the criminal justice system, the issues that plague the criminal justice system. One of the biggest drawbacks that would have plagued several administrations is their inability to operationalize law that would be passed. And albeit that it may be considered, in my humble opinion, extremely ambitious to do what is being done by this particular administration, we have to, on occasions when given the opportunity, call upon the administration to answer questions with respect to the ability to operationalize legislation that is passed. Because there may very well be a plethora of legislation coming through this House and this chamber. But being an active member of the criminal justice system, being an active member in practice as well too, there are situations that arise that don't quite mirror what is actually being done or envisioned here in this chamber or even in the other place. And it brings me back to the same point being made by the Honorable Attorney General when he spoke about decriminalization of marijuana. Now, I did not contribute to that particular debate. This is not a debate on that either at all. What I can say is that up to recently, I would have been in the magistrate's court. And the question, in terms of decriminalization, we consider the load that it puts upon the shoulders of the magistracy on every Monday morning when persons would come to court charged with offenses related to possession of marijuana. And I thought to myself, even then when we were having this discussion, that somewhere along the lines, I think the intention, as pure and as ambitious as it may have been then, is still a bit out of touch with what actually obtains. Because in most instances, in any event, just like on that Monday morning that I went to court, most persons who would have been charged for simple possession, generally with respect to the quantum or the weight that was contemplated and enacted last year, most of them would either consult with an attorney, and based upon their particular history before the court, their CR, they would usually plead guilty. And there's a number of case law, Jackman and Ragunanan, before the courts that would suggest, based upon quantum, the court should treat with them in a particular way. So that in an effort to do or operationalize what we pass, we have to appreciate how well it would work within the system. And I would have been privy to that again, as I said before, when I last went to court, recognizing that the majority of people who actually plead not guilty to matters of possession are those who have been charged with trafficking as opposed to simple possession.
So the argument advanced in most instances that work that is being done here is actually alleviating problems within the criminal justice system. In reality, it really isn't doing that. And the Attorney General, in terms of his piloting, indicated that some of the proponents within this criminal justice system that form part of this plant and machinery, this process and people, he alluded to the DPP's office and to prosecutors. And all of these laws that we are passing call upon the DPP's office as well to be actively involved, to be actively participating in terms of their management, in terms of being members within this particular suite of legislation. And most recently, Madam President, because the DPP generally does not indicate his position very often, but when he does, he sends a very clear message with what is actually taking place at his office. And most recently, in a Newsday article, Tuesday, 4th February 2020, the DPP indicates it is entitled, "The DPP pleads with AG for more support." And that would have been at a symposium speaking specifically with plea discussion and plea agreement, which we aren't dealing with here today. But the DPP indicates clearly, and I quote, "Our ambition must never outpace the support systems," Gaspard said. I heard the AG indicate that he would be making certain changes legislatively, and those changes may result in 26,000 cases being taken out of the system. If it is those matters would be taken out of the system and placed at the doorstep of the DPP's office, all I ask is that the office receive certain attention. Otherwise, the AG's ambition would remain only that. And there are many other examples where the legislation is passed through this place, is passed through the other place. But in terms of operationalizing those pieces of legislation, clearly something is going wrong. We are either talking too fast and passing legislation too fast and not ensuring that the infrastructure is in place. So when we on the opposition call upon the administration to have the necessary infrastructure at least built out, if not before or simultaneously, whilst we are debating legislation, you would definitely have a situation as being meted out and proffered by the Honorable Director of Public Prosecution. And I'm saying that we are speaking about building out capacity, which this bill represents, by increasing the retirement age for judges, who definitely do have a significant role within the justice system within our country. But what about the other significant persons who play a pivotal role within the justice system? What are we putting in place for them? And it shouldn't be that we are saying things and preaching things and proffering things to the public, but then those same persons whose names we are calling us out on bluffing, are calling us out on not misrepresenting, but are calling us out basically, that are saying to us that, listen, we are not there yet. It calls upon us to ask the government, to plead with the government, to keep a pace and abreast with the things that they are doing. Because you will definitely have a position where you are spinning top in mud. I mean, it was not mentioned by the Honorable Attorney General in his piloting of the legislation. But the judicial infrastructure as it occurs right now in South Trinidad is in a total mess. We're talking about capacity, and the capacity of the court system itself, the physical infrastructure is in a mess. We are still on a shift system at the High Court, the Supreme Court in San Fernando. The Princestown Court is still closed. This is going on months now. The Rio Claro Court is still sharing that very, very small building that could literally fit within half of this chamber is the Rio Claro Magistrates Court. Is sharing with the Princestown Court, the Princestown Magistrates Court. So when we talk about capacity and we legislate to treat with capacity here, we must not forget about those other pivotal persons, pivotal institutions that are suffering because of lack of attention as well too. We are failing them with capacity as well. And if we are serious about being holistic in our approach, we must consider their plies as well too. And I will make no apology, Madam President, with the greatest of respect, that any time I am given an opportunity to speak in this chamber, I will make mention of those issues. Right, so Madam President, as it pertains specifically to the bill, I indicated at the beginning that we must consider the environment that judicial officers are placed in. And in reviewing this particular bill, I would have had the opportunity to speak to a couple judges concerning this particular issue. And I mean, it is not beyond us at all, persons involved in the justice system, to understand generally when judges retire, before their packages with respect to pension was not as it should have been. That situation has been amended, it has been changed. But apart from that as well too, what also caused them to move on is, and I will get on that later on in my contribution, is the fact that many of those judges would have expenses still outstanding. They would have children at institutions abroad or even here locally that they would want to support. And at 65, in some instances when they leave, they are unable to meet their expenses, especially based upon the fact that when they leave the judiciary, they are not allowed to practice privately for up to 10 years. That's in the legislation. In addition to that, some of them who adopt consultancy rules, it just does not pay as it is supposed to, especially with someone who has that level of expertise. And so, our bright legal minds would tend to leave our shores and go up the Caribbean out into the Commonwealth, sometimes as even as far as The Hague and as far as Hong Kong, to ply their profession and their trade. And I mean, I could speak for myself personally. I heard the Honorable Attorney General indicate that the majority of judges that I would have had conversations with, they are like fine wine. They get better with age. Vintage adds a certain degree of distinction to their judgments, to their understanding, to advancing jurisprudence within our country. So any measure that we could implement as a parliament to tether them, to anchor them here in Trinidad and Tobago, to continue working to the benefit of the people is something that must be welcomed. But that was the environment that they existed in. But when we are considering the amendments here, what I just would want to put on the record for consideration as a parliament, holistically, we must look at a couple other things. Because we would be widening capacity, because of the myriad of changes occurring in the justice system, there's going to be, as the AG would have indicated, there's going to be advertisement. I think it has already gone out for application for several judges, several individuals to apply for judicial postings. We must also consider then, based upon this opening of the gates for persons to enter the arena, we have to consider criteria, more robust criteria with respect to those pool of people entering. And I know this may very well be for the consideration of the JLSC, but we should put it on the record so that they could also consider it as well. I also wanted to discuss the fact that we should also consider a review of all activities by judges during their tenure. I mean, we do it, those who practice in the employment arena, they would be aware of KPIs and performance assessments, and it is a discussion that is had between HR in most departments and actively working employees, which judges would be. But there should be a discussion with respect to key performance indicators with judges and routine performance assessments to ensure that the work that is being done is really to the benefit of, redound to the benefit of members of the judiciary. We should also consider frequency of judgments being written and outstanding judgments as well too. Because as much as we are widening the pool for judges to continue onwards past 65, at that juncture we should consider what judgments remain outstanding. How have judges performed in terms of writing their judgments during their tenure? I know there may be some of us that sit within this chamber who may very well be able to attest to the fact that there may have been cases that would have been heard and judgments would have been outstanding for years and years onwards. It's something that we really don't like to speak about, but it exists. In some instances, you have litigants who may very well pass on to the great beyond, and judgments remain outstanding in their matters. So those are things that we should consider as well too, and maybe the members of the JLSC should look upon those things when they are considering keeping persons onwards thereafter. At that age of 65 as well too, I think some degree of an actual medical assessment should be conducted. I know that it would have been discussed at some point in time, but it is something we should consider. As I indicated before, I personally think that the majority of individuals within that profession, as they get older, for some reason they get brighter. But still, at least in terms of appeasing members of the public with respect to the work that they are doing, some assessment is done, and it could very well in fact be made public so that persons would understand and appreciate the caliber of people that we still have at that age, demonstrating their distinction beyond question. And right, so I mentioned at the beginning this Legal Profession Act, and it's actually Section 54 of the 3rd Schedule, Part A, located on page 33 of the Act, which basically says that a person who has previously held a substantive appointment as a judge of the Supreme Court shall not appear as an attorney at law in any of the courts of Trinidad and Tobago for a period of 10 years commencing on the date of his retirement, resignation, or other termination of such appointment. And as the AG indicated, quite, I don't know, weirdly enough, at Part 2 it indicates this rule shall not apply to a person who is appointed to act as a judge in a temporary capacity. And in terms of that particular section, I inquired from judges why, because I'm a young practicing lawyer, I inquired from judges and other senior lawyers why would that have been written into the Legal Profession Act. And what they explained to me is that previously, in times gone by, if a judge was to come off the bench and then assimilate or attempt to assimilate into private practice, there was a perception held by many then that there may have been some bias or unfair or favors being meted out to that individual. In most instances, he would be appearing before some of his colleagues. He may very well appear before some of the individuals who make up the magistracy, who a short while ago would have been junior to him in his position. Lawyers at the bar may have very well treated this judge, now practicing attorney again, in a fairly different way from how they would treat other practicing attorneys. And so it was written like this, that it would allow for a significant amount of time to pass before a judge would go out into private practice. I would want to comment openly that I think we as a society, we as practicing attorneys, members of the bar, that time has now passed and changed. I can't see lawyers or even members of the judiciary or even members of the magistracy affording any more privilege to an ex-member of the bar that they would an ex-member of the bench than they would a normal member of the bar. So I think it is good that the AG would have indicated that he would have spoken to the Chief Justice for consideration for this to be amended, as I think it should. I mean, as it is right now, there's no legislation in place preventing a member of the magistracy, as soon as they finish or they retire from the magistracy, preventing them from assimilating into private practice. Magistrates do it all the time. And I can say emphatically that I have appeared in matters before the courts where magistrates would have been sometimes advocating against myself, ex-magistrates. And I definitely don't feel that they are treated any way differently, even though they are in front of colleagues that they recently had.
Senator Subas, thank you. Honorable Senators, the sitting will be suspended. We will return at 5 p.m.